Good morning, everyone. My name is Lewis Mooney. I'm a practicing barrister and the coordinator of the Bar of Ireland's Voluntary Assistance Scheme. I'm absolutely delighted that so many from the charity and NGO sector are able to join us this morning. The focus of what is now an annual event is the private benefits, untangling law and policy, and the Charities Regulator tells us that this is an area where a lot of questions arise and sometimes, I'm sure, a little bit of anxiety. The first thing that we have this morning to start us off is a pre-recorded welcome statement by the Minister for Community Development and Charities, Joe O'Brien TD, who unfortunately couldn't be with us today but wanted to join the event to welcome you all to it. Aoife, if you could just play the Minister's statement, please.
Good morning all. I would like to thank the Bar of Ireland Voluntary Assistance Scheme for your invitation to speak at this event this morning and to acknowledge your continued association with the Charities Regulator by providing the benefit of your expertise and knowledge. I know that today's presentation on law and policy in respect of private benefits is very welcome, as it is an area that can cause some confusion. My remit as Minister responsible for community development and charities encompasses a diverse range of policy areas: charities, volunteering, philanthropy, social inclusion, to name but a few. And for anyone involved in the sector, it's quite clear how all of these strands under the collective umbrella of the community and voluntary sector are intertwined and most definitely interdependent. What impacts one can impact the whole sector. Charities and the volunteers who support them deserve recognition and support, as do those who sit on boards as charity trustees or who are otherwise active in the sector. They provide vital support to our communities, and I want to thank them for this. I need hardly remind you this morning, of course, of the immediate impact COVID-19 has had on the most vulnerable people in our communities, and it's important this morning to acknowledge how the community and voluntary sector has stepped up to the plate during these challenging times by being adaptable, innovative, also by being the conduit of the goodwill, the generosity and the solidarity of the public at large with people who have been particularly impacted by the pandemic. In recent years, confidence in the charity sector has taken a few knocks due to the actions of a small minority. I'm glad to say that this perception is being rectified. We owe it to the charities and the volunteers, and ultimately to the people in need of their assistance, to continue our efforts in this regard. Confidence in the sector is a huge influencer on fundraising, philanthropy, and indeed on volunteering. We can build this confidence through appropriate regulation as well as legal and financial guidance and structure. These are intrinsic elements of a stable and thriving community and voluntary sector. The Charities Regulator has done much work to increase public trust and confidence in the sector, especially when considering its range of functions and wide reach, from the smallest of charities with no staff, run entirely by volunteers, to much bigger and better funded organisations. To cater for all of these charities, a practical approach and a common sense attitude is required, and these are very much in evidence in the regulator's publication on compliance and accountability, ensuring proportionality and on supporting best practice in governance and in administration. This guidance is especially helpful to smaller charities who can sometimes be overwhelmed by what can seem like an insurmountable amount of paperwork, and to their charity trustees indeed who work in a voluntary capacity. Charity trustees have an important responsibility in ensuring good governance and are often faced with complex decisions, and it's important that training, guidance and support is available to them. This is why events like this morning and the interest of professional bodies such as the Bar of Ireland through its Voluntary Assistance Scheme do us all a great service. By providing valuable expertise and assistance to charities, you enable them navigate difficult waters with confidence, providing a service which many simply could not afford. Last December, I was truly delighted to launch our first ever national volunteering strategy, the purpose of which is to recognise, promote and grow the unique value and contribution volunteers make to Irish society. The strategy also provides an opportunity for government to acknowledge how important volunteering is to the well-being of the nation. The strategy recognises that volunteering is diverse. It happens formally, informally, and ranges from decades of continuing commitment, supporting community events, for example, to lending a hand when needed. And that while volunteering is a critical part of the community and voluntary sector, it also sits outside in the private sector, in the professions, in politics, in sport, and with the individual. Another aim of the strategy is to increase awareness of and facilitate greater understanding around the model of professional skills volunteering. Pro bono support and skills-based volunteering provides an opportunity for businesses and individuals to partner with charities to assist them in delivering their organisational objectives. Research has proven that skills-based volunteering has a huge impact, and there are many examples of professional skills sharing, from those who are expert in marketing, IT, HR, finance, sales, consultancy, and of course the law and compliance. The volunteering strategy seeks to promote and facilitate greater understanding around this model of professional skills volunteering. This also complements the model of task-based volunteering as an alternative to role-based volunteering, where people can volunteer for a task or lend a particular skill rather than committing to a role which in the long term they may feel unable to fulfill. In conclusion, I would like to commend the Voluntary Assistance Scheme, which as a pro bono scheme of the Bar of Ireland assists organisations that are working with some of the most vulnerable people in society to access the legal system. I hope you enjoyed the event this morning, and I do appreciate the opportunity to address you. Apologies I couldn't be there in person. Thank you.
We're now going to go to a number of presentations and then that will be followed by a question and answer session, which will be joined by Helen Martin, the Chief Executive of the Charities Regulator. At this stage of the event, I just want to take the opportunity to really personally thank the speakers both for their time and expertise and their generosity in respect of both. If during the event you have a question that pops into your head during a presentation, we would really encourage you to place that question in the right-hand panel of your screen. We will then be able to record that question and put it to our speakers and Helen Martin during the course of the question and answer session. I'm now going to hand over to Turlough O'Donnell, who is a practicing senior counsel, a former chair of the Bar of Ireland, and most importantly, from the point of view of this morning, a founder of the Voluntary Assistance Scheme, who is going to introduce the first speaker for us. Thank you very much.
Good morning, everybody, and thank you for the enormous show of support. Thank you also to the Minister for his words. The purpose of the Voluntary Assistance Scheme is to allow barristers engage in conversations and dialogue with people who normally wouldn't have good access to the law. It's an ongoing conversation, and we hope to provide to the voluntary sector the very best of legal advice from the depths of the experience of the bar. I want to just say that the Voluntary Assistance Scheme was established so that people could have, who normally wouldn't have access to the bar, could have access to the bar, and that has proved to be the case. Now, we have an excellent speaker now, Neil Steen, Senior Counsel, who is going to address us, and I'm looking forward to the presentation almost as much as I'm sure that you all are. So I'll hand over to Neil Steen, Senior Counsel.
Good morning, everyone, and thank you, Turlough. It is my pleasure to have been afforded the opportunity by the Bar's Voluntary Assistance Scheme to speak to you this morning on the subject of private benefit in charity law. And I'm doing so in conjunction with Thomas Mulholland, the Head of Compliance at the Charities Regulator. Tom has unmatched experience of the practical day-to-day aspects of addressing issues relating to private benefit, where I, of course, defer to him. We thought it might, however, be useful if I were to provide an outline of the historical and legal context in which these more practical questions arise, and that is what I propose to do. Now, I hope I will be forgiven for not delving into some of the darker historical recesses which are, in any event, beyond my ken. The complexity of this area of the law is perhaps reflected by the fact that a great English equity lawyer, Lord Evershed, referred in a paper he once delivered to the Sydney Law Review to the well-known caricature of the promising Chancery Junior of 80 years of age. Now, although I'm further along the path towards 80 than I used to be, I confess that I have not quite reached the promising stage yet. The law relating to charities derives principally from the law of trusts. The concept of the trust is one of the most important developments in English law, which we in Ireland have inherited. Perhaps its key characteristic is that it allows for the ownership of property to be split. It is said that one person owns the property in law while another owns it in equity. This is a reference to the system of rules, the rules of equity, that developed in parallel with the judge-made law that we call the common law under the auspices of the Lord Chancellor in the court that he administered, the Court of Chancery. Historically, the Lord Chancellor was an ecclesiastical figure, and the rules that developed in his court were often a reaction to the strictness and perceived unfairness of the common law. The courts of common law and equity were in this early period quite separate. Indeed, the Court of Chancery was one of the original 4 courts in the building that now bears that name. The courts of law and equity have been amalgamated since the late 19th century, but prior to this it was the courts of equity that first accepted that property could belong to someone but not fully belong to them, because it had to be held for the benefit of someone else. That is to say, the property was held by the legal owner in trust for another. The owner, the trustee, is the owner in law, but the person for whose benefit the property is held, the beneficiary, may be considered the owner in equity. Where property is held by one person, let us call him A, in trust for one other person, B, the position is relatively straightforward. A is the legal owner and B is the beneficial owner. A owes a duty to B to take care of the property according to the terms of the trust. He owes duties of trust and confidence, referred to as fiduciary duties, to B, and if A fails in those duties, B can enforce them by legal action. Where A holds property in trust for more than one person, for B, C and D say, the position can be more complex, but we still speak of A as the legal owner and the entire beneficial interest being held by B, C and D together. If A fails to perform his fiduciary duties, they can be enforced by the beneficiaries. But what if there were no beneficiaries? What if property were to be held on trust for certain purposes, without any persons being identified as objects of the trust? This situation presents problems for the law, both theoretical and practical. A theoretical difficulty arises because we have a legal owner, the trustee, but no beneficial owner. Where has the beneficial ownership gone? Generally, the law adopts an approach to property similar to the laws of classical physics in relation to the conservation of mass. Property, like matter, cannot be created or destroyed. It must be somewhere, which is to say, things, including beneficial interests in things, must belong to someone. However, the law has seldom been fully constrained by pure logic, and exceptions have a way of being made where this seems to produce a just outcome. The more practical difficulty is this: who can enforce a trustee's fiduciary obligations when there is no beneficiary? Allied to these concerns is the fact that it has long been the policy of the law not to allow property to be tied up in trusts for very lengthy periods of time, with the result that the capital in question effectively is taken out of circulation and rendered sterile. A trust that requires capital to be maintained indefinitely with only the interest on the capital being devoted to the purpose in question offends against this instinct of the law. These problems do, however, explain the law's reluctance to recognise what are called purpose trusts. It is not that such trusts are never valid. Never is a big word in any area of the law, but it is true to say that they are exceptional and are treated as such. Where purpose trusts have been allowed, they have sometimes been described as concessions to human weakness or sentiment. The classic example is a trust in a will for the maintenance of a beloved pet animal after the owner's death. A sum of money left on trust for the care of Fluffy the cat will be upheld, not because Fluffy is the beneficial owner of the settled property, or because he can sue to ensure that the duty to him is fulfilled. Of course, he can do neither. But we would prefer to see him cared for rather than not, and in particular, we would prefer his owner's mind to be at ease knowing that he will be cared for. There is also the consideration that we think it unlikely Fluffy will tie up the money involved for all that long. That being said, in the Irish case of Ray Kelly in the 1930s, which was concerned with a trust for the care of the testator's dogs, Mr. Justice Meredith commented dryly that while the court knew nothing of a dog's expectation of life, in point of fact, he said, neighbours' dogs and cats are unpleasantly long-lived. Be that as it may, by far the most important exception to the general rule that purpose trusts will not be upheld is that which allows for purpose trusts where the purpose is charitable, also known as charitable trusts. The law in relation to charitable trusts is often traced back to the Charitable Uses Act of 1601, although Chief Justice Keane has said that the jurisdiction probably dates back to an even earlier time. Although the statute is long since repealed, as recently as 1995, its preamble was being referred to by the court as providing what they called an index to charities recognised by law. In the Charities Act of 1961, the term charity was not defined, hence the recourse to legislation passed in the reign of Queen Elizabeth I. In the important 19th century case of the Commissioners for Special Purposes of Income Tax and PEMSL, Lord Macnaghten, speaking in the UK House of Lords, said, "Charity in its legal sense comprises four principal divisions. 1. Trusts for the relief of poverty. 2. Trusts for the advancement of education. 3. Trusts for the advancement of religion. And 4. Trusts for other purposes beneficial to the community, not falling under any of the preceding heads." Little has changed since. The Charities Act of 2009 now defines charitable purpose as A. The prevention or relief of poverty or economic hardship, B. The advancement of education, C. The advancement of religion, and D. Any other purpose that is of benefit to the community. The last residual category is further expanded upon in Section 3 of the Act, which clarifies, for example, that protection of the natural environment and the advancement of environmental sustainability are purposes of benefit to the community. Responsibility for enforcing charitable trusts has traditionally rested with the Attorney General. Under the 2009 Act, that responsibility has now been transferred to the Charities Regulator, and in this way, the practical problem that I mentioned of enforcement is solved, and that, of course, is Tom's bread and butter. As for the theoretical difficulty I mentioned in relation to purpose trusts, that is the question of who really owns the property, this is not merely overlooked in the case of charitable trusts, it is almost inverted. That is to say, not merely is private benefit to identifiable individuals not required, its presence may actually lead to a putative charitable trust failing. The reason is that in all charitable trusts, there is an overriding requirement of public benefit. This is now found in Section 3, subsection 2 of the Charities Act 2009, which states, quote, "A purpose shall not be a charitable purpose unless it is of public benefit." Purpose trusts that do not provide sufficient public benefit to be regarded as charitable will fail. An example is provided by the bequest of the disarmingly self-regarding testator in the 1960 case of Ray Endicott. There, the Court of Appeal of England and Wales had to consider a bequest by a testator for the purpose, admirable at least for its directness, quote, "of providing some useful memorial to myself." The court held, perhaps unsurprisingly, that this was a purpose that did not qualify as charitable. In that case, it was difficult to identify any real benefit to anyone, but there are cases in which a benefit may be clear, yet a trust cannot be regarded as charitable because the benefit is not sufficiently public. The requirement of public benefit is incompatible with an intention to confer what are more properly described as merely private benefits. So, for example, a trust established for the purpose of funding expensive medical treatment for an impoverished friend could be viewed as a trust for the relief of poverty, or a trust for the relief of illness, which falls within the residual category of other beneficial purposes. But such a trust would be most unlikely to be treated as charitable, as its defining characteristic is that it confers a private benefit on the individual concerned. It therefore lacks the necessary element of public benefit. The balance to be struck between public and private benefit is ultimately a matter for judgment to be arrived at on a case-by-case analysis. Per trust for the relief of poverty being concerned, public benefit has always been strongly presumed by the courts. The result historically has been that a good deal of latitude has been afforded in the case of such trusts, and a degree of connection between testators and the class of persons who might benefit from their largesse has often been tolerated. It has been said by no less an authority than the aforementioned Lord Evershed that these so-called poor relations cases, where a group of the testator's relatives have been potential objects of the relief of poverty, quote, may be justified on the basis that the relief of poverty is of so altruistic a character that the public element may necessarily be inferred thereby, or they may be accepted as a hallowed, if illogical, exception. And under Irish law, trusts for the advancement of religion were and continue to be presumed by statute to occasion public benefit. This was provided for in both the Charities Act of 1961 and in that of 2009. The difference between the two acts is that the public benefit is no longer presumed conclusively. Historically, The Irish courts, for example, more readily reached the conclusion than their English counterparts that trusts for the celebration of private masses involved sufficient public benefit to be treated as charitable. The 2009 Act now clarifies the interaction between public and private benefits somewhat. In Section 2, subsection 1, it defines a charitable organisation as a charitable trust or a body corporate or an unincorporated body of persons, A, that is established for or promotes a charitable purpose only, and B, which is required under its deed of trust or constitution to apply all of its property in furtherance of that purpose. Now, we've already looked at the categories of charitable purpose and noted that they are subject to the overriding requirement of public benefit. Section 3, subsection 7 of the 2009 Act provides that in determining whether a gift is of public benefit, account shall be taken of any limitation imposed by the donor of the gift on the class of persons who may benefit from the gift. And in this connection, Section 3, subsection 8 provides that such a limitation shall not be treated as justified and reasonable if all or a significant number of the intended beneficiaries have a personal connection with the donor. This suggests that the poor relations exception is an exception no longer. Given that charitable status carries with it particular tax advantages, it is unlikely that the Revenue Commissioners would accept without demur that a trust intended to transfer wealth to the poorer members of a testator's family should qualify as charitable, rather than simply a way of conferring a private benefit subject to taxation in the normal way. Now, all this being said, the reality is that even in the case of a charitable trust, some element of private benefit is unavoidable. In the first instance, almost all charitable trusts end up conferring a benefit on individuals whose circumstances place them within the scope of the charitable object. The poor who receive assistance from a trust for the relief of poverty, the sick who receive medical treatment from a trust for the relief of illness. If they did not, the charitable purpose could never be carried into effect. Furthermore, even persons not squarely within the class to which the assistance is primarily directed frequently benefit also. So, in the English case of Catholic Care versus Charity Commission for England and Wales, the then Mr. Justice Briggs, now Lord Briggs of the UK Supreme Court said, this is a quote, "Charities do not strictly exist to serve a beneficial class. They serve publicly beneficial purposes. Nonetheless, even if certain familiar types of charity may loosely be described as serving a beneficial class, it is by no means uncommon for them to achieve that purpose by conferring benefits on persons outside that class. For example, a charity for the relief of sickness may serve that purpose by providing benefits to nurses or to the hospital employing those nurses. A charity for the relief of the disabled may serve its purpose by providing respite care, for example, holidays, for the relatives of the disabled who care for them at home. Similarly, Catholic Care and similar charitable adoption agencies serve needy children by making benefits available to prospective adoptive parents. It is a feature of the dependency caused by youth, sickness, disability and old age that relief can often best be achieved by conferring benefits on the carers rather than directly upon the cared. Benefits such as these are inherent in very many charitable objects and are likely to be considered and addressed at the time the charitable trust or organisation is first established. Of more practical significance to the day-to-day operation of charitable trusts and organisations is the possibility of benefits being provided to those who are concerned in the administration of the charity. The Charities Act 2009 recognises that a charitable organisation may employ staff to perform duties. It may even pay them. This is an express exception to the rule that all the organisation's property must be applied to its charitable purpose. Now, while one can certainly plausibly contend that it is through the employment of staff that the charitable purpose is effected, employees undoubtedly do benefit from the use of the organisation's funds. Provided the arrangements are reasonable, this does not disqualify the organisation from charitable status. There is a distinction to be drawn between employees on the one hand and on the other hand, charity trustees who are defined as the trustees of a charitable trust or the officers of a company or unincorporated association qualifying as a charitable organisation. The Act of 2009 contains a provision, Section 89, which was obviously intended to provide greater clarity in relation to the sort of arrangements that a charitable organisation might enter into without breaching the rule on conferring private benefits. However, the section has never been commenced. It is nonetheless of interest. Essentially, it would have allowed charitable organisations to enter into written agreements with relevant persons providing services for award to such organisations if the charity trustees were satisfied that this would be in the best interests of the organisation. Relevant persons are defined as charity trustees or persons having a personal connection with them. So in short, Section 89 contemplated charity trustees and their family members receiving payments for services from the charitable organisations which they serve. However, as Section 89 is not in force, the current position is that the regulation of agreements between charity trustees and charitable trusts and organisations is less clear than might be thought desirable. We are therefore thrown back upon the general law and on the provisions we have already noted in relation to the requirement to devote all property to the charitable purpose. The starting point must be that all situations in which a charitable trustee stands to obtain a pecuniary benefit from his or her relationship with a charitable organisation are to be avoided. It is a general principle of trust law that a fiduciary should not profit from his office, and where he does, he may be liable to repay the profit to the trust. As we have seen, a charitable organisation is not prohibited from retaining staff who may benefit from payment of their salaries, but no trustee can hold such a position of remuneration. One consequence of this arrangement is that it tends to give effect to what is often regarded as the ideal separation of functions as a matter of broader corporate governance between a policy-making board and an executive responsible to the board for implementing that policy. In the case of charitable organisations, the division between board and executive is therefore unusually strict because a board member cannot be a paid member of the executive. While charity trustees cannot profit from their offices, neither can they be expected personally to bear all the out-of-pocket expenses associated with performing their duties. Expenses properly incurred by trustees and by executive staff may be reimbursed from the charitable organisation's assets. In all such cases, it is imperative that the expenses be reasonably incurred, documented and vouched. Many of the investigations carried out by the Charities Regulator have touched on issues concerning the proper vouching and, importantly, advance justification of expenses. For example, in the Inspector's report of July 2017 into Ataxia Ireland, the inspectors, quote, noted governance level approval for foreign travel to international conferences, close quote, and, quote, found that the approval was not informed by any estimates of the total cost of travel and subsistence to attend such conference events or, importantly, a prior business case setting out the benefits to the charity, end quote. There may also be situations in which some conflict of interest is unavoidable. The Charities Regulator has published guidance in May 2018 on managing such conflicts. This guidance is available on its website, which is a valuable resource for anyone involved in the charity sector. And now, in parallel with all these rules of law, there is what may in reality be the overriding consideration, that of public confidence. Most charitable organisations depend for their ability to carry out their functions, at least to a significant extent, on donations from members of the public. If a charity is revealed to have used such donations to fund private benefits for staff or trustees, the reputational harm could be catastrophic. Individuals who give their hard-earned money to a charity expect it to be devoted to the charitable object, not to the funding of luxurious expense accounts. In this area of life, as in many others, sunlight is often the best disinfectant. Any charity considering a transaction that might possibly be regarded as conferring a private benefit would do well to begin by asking itself, how would this look to one of our donors? And in cases of doubt, the prudent course will usually be to say no to it. In conclusion, I hope that this whistle-stop tour through the development of charities law has managed to bring up at least some points of interest. Those involved in the administration of charities shoulder important responsibilities upon the proper performance of which much societal good depends. The office of charitable trustee in particular is one of significant responsibility which must be undertaken without any real hope or expectation of financial reward and out of a sense of genuine altruism. Charitable trustees and the staff who assist them are therefore rightly deserving of our praise and support for the important work they do. Through the Voluntary Assistance Scheme, we at the Bar, even those of us who have yet to attain promising status, hope to be able to provide some practical assistance to you who keep the charities sector running. We do so along with our gratitude and admiration. Thank you.
Thank you very much, Neil, for that really insightful presentation. Just at this stage of the presentations, I just want to encourage you all to ask as many questions as you might have and that pop into your head during the course of those presentations. Again, on the right-hand side, there have been a number of questions, but we welcome many more for the question and answer session to make it as fruitful as possible for you. It now falls to me to have the great pleasure of introducing Thomas Mulholland, the Head of Compliance and Enforcement at the Charities Regulator. Thomas is responsible for overseeing the concerns function and the investigations function of the Charities Regulator. He previously worked in the Office of Director of Corporate Enforcement and is a qualified accountant with 15 years experience in private practice. And Thomas is going to be able to speak to many of the practical issues, some of the problems that arise, and hopefully we'll be able to give you some guidance in respect of this very complex area. So Thomas, I'll hand over to you. Thanks so much.
Thank you, Lewis. So like Lewis said, my name is Tom Mulholland. I'm Director of Compliance and Enforcement with the Charities Regulator, and I'm here to give a presentation on private benefits. So I'd like to thank the Bar of Ireland for the opportunity to give this presentation and have the opportunity to talk to people in legal practice and also to charities and charity trustees. So first of all, I'm going to start with the Charities Act 2009. Now, I know Neil had given a very interesting presentation there in all the legal aspects of the Act, and I'm not going to pretend to have his level of knowledge in relation to legal matters. But still, I think it's important to run through some of the main points that are relevant to our day-to-day work in the Charities Regulator, because all the actions that we take in the Charities Regulator are ultimately based on our powers within the Charities Act 2009. So the Charities Regulator was established in 2014, even though the Charities Act was passed in 2009. It was 2014 before the Charities Regulator came into being. So we're quite a young organisation even at this stage. And at the outset, I would just like to emphasise that while all our actions, like I said, are based in the Charities Act of 2009. The vast majority of our interactions with charities are on a voluntary basis. So even in the compliance function, if we have issues that we have to deal with charities are very much open to dealing with us on a voluntary basis. To provide we write to them on a voluntary basis, and they provide information. And normally, most issues are sorted out entirely on a voluntary basis. So there's not really a requirement to use our statutory powers on a regular basis. Now, it does happen, but I just want to emphasise that charities generally comply with any requests or information on a voluntary basis. Now, I'm going to go through some of the terms that are defined in the Act. I know Neil touched on these, but again, we do rely on these in our day-to-day interactions with charities. And our first one is in relation to charitable organisations, which is defined in Section 2 of the Act. And so this states that a charitable organisation is made up of the trustees of a charitable trust or a body corporate or an unincorporated body of persons. And that's important because that makes it clear that the trustees are the responsible party in relation to any charity. So if ever we're issuing correspondence, we'll be issuing it for the attention of the trustees of the charity, because they are in control. They are ultimately the decision makers in any charity and are responsible for all actions of that charity. We'll be very clear on that. Obviously, a charitable organisation must promote a charitable purpose only, and again, that is vital. It's very clearly set in the Act. It must promote a charitable purpose only. So a charity can't be part-time charity, part-time business. That's not the way it can operate. All its activity, all of its intentions must be in promotion of the charitable purpose. And then again, I think Neil touched on this part as well, about under its constitution, a charity is required to apply all of its property, both real and personal, in furtherance of that purpose. So I think that's probably the key section of the Act that is relevant to our discussion today in relation to private benefit. It's clear there under the Act that all of the income, all of the assets of the charity must be applied to the furtherance of the charitable purpose. Now, in fairness, the Act recognises that on a day-to-day basis, there's charities have to be operated, they have to be run, there's costs involved in running a charity, and that's recognised again in the Act. It said it gives an exception for monies expended in the operation and maintenance of the body, so that makes sense, that a charity has to have has day-to-day costs, has phone, has light and heat, rent of an office, and they're absolutely necessary for running a lot of charities. And it also recognises that money is paid in remuneration of members of the staff of the body. So again, that makes sense. If a charity has employees, it has to pay those employees. Those employees are entitled to their employment rights, the same as employees in any business, that they have the exact same rights, employment rights, holiday pay, sickness rights, all that kind of thing. And it's important to recognise that charities fall into the same category. They must respect those employment rights. So the next section I'm going to refer to in the Act is Section 3, where the term public benefit is defined. And again, our talk here today is about private benefit, but that's not defined in the Act. So if we have an understanding of the public benefit, that can assist us in our understanding of private benefit. So it says a purpose has to be a charitable purpose. It has to be of public benefit, so it has to benefit the public, and it is intended, this public benefit is intended to benefit the public or a section of the public. And again, Neil touched on this example where in relation to a person who perhaps is ill, and it often happens, people say there may be a child who may be sick, and the local community may get together to raise funds in relation to assist that child. Perhaps it may have a very rare disease and may require specialist treatment abroad, and the question arises, is that a charity? Well, the short answer to that is no, because that is not a charity, because there's not a public benefit. The benefit is only to that specific individual. Now, although it's laudable and absolutely there's a good community spirit in helping out a situation like that, it just doesn't fall under the definition of a charity. Now, to give an extreme example, if there were a case where there was a child with a very rare illness, say, and it was the only child in Ireland that suffered from that illness. If that were the case, and a charity was to set up which would help anybody who happens to suffer from that illness. Now, and in this particular case, only one child actually suffered from that illness. That could be a charity in theory, as long as if somebody else, another person were to suffer from sale illness, that they would also be able to benefit from that charity. So the charity set up for the purpose of assisting people with the illness, not assisting the individual person. It's also the Act also goes on in Section 3 to say that the public benefit must be conferred on a person other than in his or her capacity as a member of the public or a section of the public. Any such benefit is reasonable in all of the circumstances and is ancillary to and necessary for the furtherance of that public benefit. Okay, so that makes sense. And again, Neil touched on this on a day-to-day basis. That happens that charities, they do, as part of the function of the charity, there is a kind of incidental private benefit to certain people, and that's acceptable as long as it's ancillary to and necessary for the furtherance of the public benefit. An example I'm going to give there is in relation to a charity that applied for a charitable status some time ago in relation to flying greyhounds. And what this charity was set up to do was to look after greyhounds who were unwanted or weren't able to perform anymore. And apparently greyhounds as pets are in demand in America. So this charity was set up to take some of these greyhounds and fly them to America. Now, to get to America, as part of the application setting out the intentions of this charity, it was clear that somebody would have to fly with the greyhounds. Their flight would have to be paid for to America. They would have to be accommodated in America whilst the animals were passing through customs and being handed over to the authorities over there. And so there's a private benefit was accruing to that person. Whoever was getting their flight paid to America, they were getting their accommodation in America for the night or two that they were staying there. And the question arises, well, is that a private benefit? Well, it is a private benefit in the sense that the person is getting their flight paid for, but in the circumstances, it's required, it's necessary for the running of the specific running of that charity, and it was reasonable. So that is an example of a charity that was registered because it was reasonable that would be an incidental cost of running the charity. So again, the Charities Act, just going back to it again, the last section we're going to mention where public benefit is mentioned is in relation to section 14, and that just talks about the general functions of the Charities Regulator. And one of our functions is to promote understanding of the requirement that charitable purposes confer a public benefit. So that's just like today, giving public talks in relation to public benefit. So I'm going to give a quick overview of the Charities Regulator itself. There's about 40 staff in the Charities Regulator. Currently, there's about 11,500 charities on the register of charities, so quite a number of charities. There's over 74,000 charity trustees registered on the register of charities. Okay, so there's quite large numbers of charities and charity trustees. Now, as part of my function as Director of Compliance and Enforcement, part of my remit is to look after complaints, or as we call them in the Charities Regulator, concerns. So I have to deal with concerns that are notified to the Charities Regulator, and we get concerns all the time, and concerns can range from any, or can come from any kind of concern can be raised, and they can come from very perhaps banal or minor issues. Perhaps somebody might complain or raise a concern in relation to a picture of a donkey on the front of a brochure by a charity, that the donkey doesn't look sad or looks sad or something like that. Some very minor issue to quite serious issues. We can get concerns in, alleging, serious fraud and governance issues within a charity. So obviously all concerns are looked into and are all treated in a proportionate manner. So the figures for the concerns received for the last number of years, in 2019 there were 649 concerns. In 2020 there were a drop to 466 concerns. I think that was probably, like everything else, the COVID-19 had an impact on the activities of charities, and so there was a corresponding drop in the number of concerns raised with the Charities Regulator. So while on the face of it, 466 or 649 concerns may sound like a lot of concerns to receive, a lot of those concerns actually would be in relation to entities that are not registered charities. So maybe approximately half of them would be in relation to entities that are not charities, that perhaps are holding themselves out as charities, or when we look at them, they're actually not charities. So what I'm really trying to get across here is that although the number of concerns may look like a large number, when you look at it in the context of 11,500 charities, it's really not a large number of concerns in relation to charities. So I think it's fair to say that the vast majority of charity trustees carry out the duties with the best of intentions. So my sense of interacting with charities on a day-to-day basis and dealing with them and charity trustees is that they're there for the widespread for the good of their charities, for the good of the work they're doing. They contribute to society, and I think it's fair to say that charities, for the most part, are contributing to good and are well run, and people have the best of intentions in running charities. And I think also that it's fair to say there's a common understanding. If you ask people in generally, it would be generally understood by the public in general that those involved in charities, charity trustees and the volunteers and support should not receive any private benefit from a charity. I think that's relatively well understood. I don't think anybody would really dispute that. So here I have just a quick breakdown of the number of concerns received each year. Now these are figures for 2018 and 2019. So you can see the top 3 issues that we receive as concerns in the Charities Regulator. So when we get a concern, we would categorise each concern, and it would categorise them by the main element of the concern raised. So the top 3 concerns we receive are legitimacy of charity, governance issues, and financial control and transparency. And those 3 areas would cover the vast majority of concerns we receive. So concerns in relation to private benefit, now this is just where private benefit only has been raised as a concern, is quite low. It's probably surprisingly low. But perhaps that just goes to show that, you know, most people have an understanding of private benefit and charities themselves. It's not really as major an issue for charities as you might imagine. Now, having said that, it does come up as part of private benefit may also be part of, you know, of these other concerns. Governance issue may be the main concern, but private benefit could also be part of the governance concern. So private benefit certainly does come up as an issue in charities. So like I say, private benefit does come up as an issue that the Charities Regulator has to deal with, and a lot of the time it can be based on a misperception by the concernee, because they may not have all the information. So this is an example of people, you know, somebody may see something in a charity, and because they don't have all the information, they may raise a concern with us and say there's something going on to this charity, it's not right. And then when we look into it, we get all the information from the charity, and we find out, in fact, it's fine. An example I'm going to give is in relation to an employee who's getting their taxi paid to travel to and from work for the charity. Now, normally it would not be appropriate for a charity to pay for their employee to travel to and from work by taxi, and for the charity to incur that cost. That would not normally be acceptable. But in this particular instance, the charity was involved in counselling services, and one of the counsellors had received threats of violence from an individual, and as part of the charity's reaction to protect their employee, and obviously the charity, like I said earlier, has to protect their employees, look after their employees the same as any employer. As part of the plan that was put into place to look after that employee, they arranged for the taxi to bring that person to and from work for a certain length of time until the issue was resolved. Now, so again, once that was brought to our attention, once that we looked into it, that was fine. Now, the person who raised the concern, they weren't aware of that issue, and so, but once we looked into it, we could see that was fine. Now, as long as a situation like that would be kept under review, if that just wouldn't continue on a long-term basis, there's no issue with that. The other issue is that sometimes one issue may be reported to us, say, in relation to private benefit, but when we look into it and we interact with charity, we may come across a number of issues that come to light in the charity. So, like I say, private benefit could be the initial concern we receive, but when we deal with the charity, we find out other issues, for example, that the listing of charity trustees is not up to date, or that maybe employee contracts are not in place, or some of the other things that need to be corrected or sorted out within the charity. So that's quite a common occurrence. But like I say, I want to emphasise again that the vast majority of concerns raised with the Charities Regulator are addressed by charities on a voluntary basis, and we do not have to exercise our statutory powers. So I'm in my role as Director of Compliance and Enforcement, I am, aware that, I perhaps deal with all the, the issues, all the problems that arise, and, but we try not to let that colour our view. We try to take a proportionate response to any concern we receive, and obviously give charities the opportunity to deal with those and to answer any queries we raise, which they do on a voluntary basis on the most part. Now, as Neil touched on earlier on, sometimes issues come up and they can be kind of a grey area. So a grey area can come up where it's not clear whether something is a private benefit or whether it's incidental to the charitable purpose of the charity, and these have to be looked on a case-by-case basis, exactly as Neil said. So my rule of thumb for charity trustees, if we're discussing an issue with a charity trustee, the way I would put it to the charity trustee is this: if the issue we're talking about, if this was public knowledge, if everybody knew about this, it was in the papers, would you continue on this course of action, or would you stop it? So if the charity trustees come back to me and say, well, if everybody knew about this, we wouldn't continue doing it, we'd change the way we do it. Well, I would say my response to them would be, then you shouldn't be doing it in the first place. Okay, if you're not prepared to have this, carry on this activity, if everybody knew about it, you shouldn't be doing it. And that's distinct now from getting everybody to agree with your actions. Now, it's impossible for, charity trustees have to make decisions. They have to call things as they see it to the best of their ability. And one of the functions of making a decision is that not everybody's going to agree with your decision. So I'm not saying that the Charities Regulator or everybody in general has to agree with your decision. What I'm saying is you must be prepared as a charity trustee to defend your decision, to stand over it. And I was struck by Neil's comment earlier on where he said, you know, sunlight is often the best disinfectant. So that's probably a term I'm going to steal from Neil. I'm going to use it myself. I think it's very, you know, it's a good way of looking at things. If everything was out in the open, would you continue on this course of action? So, like I said, there may be an exchange of views between the Charities Regulator and the charity in relation to an issue, and you know, perhaps we can share our view with the charity, and they could share their view with us. And you know, there was normally, like say, a resolution. And again, like Neil said, the reputational risk for charities is key here. Instances of extravagant spending can severely damage a charity's reputation, and it can have a negative impact on fundraising, and that really is a risk for charities. If you know, a newspaper article or some kind of social media stories alleging, you know, extravagant spending within a charity, that can be an existential risk for charities. The charity could be closed down over an issue like that. So they tend to be respond to any kind of query in relation to private benefit, because they know the risks they run of issues like that not being dealt with. Now, having said that, even with interaction with charities and the fact, like I said, that most charities are, you know, these things are resolved on a voluntary basis, sometimes serious issues do come up, and perhaps the charity may not either initially acknowledge or comprehend the seriousness of a private benefit issue. And an example I'm going to give is in relation to a charity we were dealing with. It's a small charity from the west of Ireland, I think, and this charity had an agreement with a private clothing collection company. And this private clothing collection company had clothing bins located in different areas, and people would put clothing into the bin, and this private company would basically, you know, process those clothes and sell them. Now, the private clothing collecting company approached the charity and said, look, can we use your logo on our bins, and we'll give you a donation of €100 a month. And the charity, which was quite a small charity, said, oh yeah, that's a good idea. You can go ahead and use our logo. We'll get €100 a month out of it. Now, when this was brought to our attention, we approached the charity, and initially they didn't see any issue with this. But then when we were asking them, well, there's an issue about private benefit here, because how can you, are you satisfied as a charity that you're getting more out of this arrangement than the clothing collection company is? Like, is there not a benefit to this clothing collection company? Is, and you don't know how much money they're making out of it, and they're merely giving you €100 a month. So once that was kind of looked at by the charity, they did cancel the contract with the clothing collection company. But again, there was a reputational risk here, because they had an issue over the control of their logo, which had been used by this private clothing collection company, and they weren't aware of, you know, how long it had been used for, or, you know, where it had been used. Like, it actually came as a bit of a surprise to the charity when it was pointed out to them that these bins were located all over the country. It wasn't just in the local area. So again, there was a reputational risk to that charity in the use of their logo. Now, serious issues, so even more serious issues than that can come to light with the Charities Regulator. And my experience of it, you know, just my experience of it, it tends to happen a lot in a long established charities where practices develop over time. So, and then when you query this practice with a charity, you find there's no rationale for it. It's lost in the midst of time exactly why this has been happening, or what the reason behind it is. It's just, you know, it's always been done. But when you ask them why, they just can't remember, or they just don't know. An example would be where travel expenses, well, perhaps it's perfectly legitimate for a charity to pay travel expenses for employees, but then when it may come to our attention that the travel expenses are being paid are way above the revenue guidelines. And again, you know, you query this with the charity, and they may say, well, we just don't know why. That's always been the rate, and we would have to point to them, well, that's not acceptable. there should be a policy in place that should be in line with revenue guidelines in this instance. Or perhaps the charity may allow something like travel to work as an expense, again, which would not be acceptable, or round sum amounts, just a round sum payment of €200 a month to a person for expenses. These would all not be allowable. They would not be in keeping with the principle of promotion, of applying all assets of the charity to the promotion of the charitable purpose. Okay, there's an element of private benefit there. There's also a risk for charity, not only from, maybe compliance from the Charities Regulator. There's also a risk from other entities such as the Revenue Commissioners. If an issue like this came to light, it could lead to a revenue liability, and revenue liability could build up over quite a period of time, and it could be quite expensive. So there's a financial risk to issues like this coming to light and not being dealt with by charities. And again, my experience of these things is that these kind of issues tend to happen in charities which are dominated by a single individual or maybe a small group of individuals. It could be a single trustee, one of the trustees, or perhaps a founder, the original founder of the charity, or where there's too much control by a single entity, like a family may have too much influence in relation to a charity. And the issue then is that even though there may be a board of trustees in place, they tend to be weak. They tend not to challenge the dominant trustee, and there may be phrases used when it's queried with them, like the other trustees may say things like, oh, they didn't like asking questions about this of this person because they get upset about it, or they didn't like being questioned. Now, as far as the Charities Regulator is concerned, that kind of response is not acceptable. If you're the trustee of a charity, if you don't, you must ask the hard questions. You're responsible, the same as all the other trustees, for the assets of the charity and for running the charity, for governance of charity in a proper manner. And also, when perhaps the person who is receiving benefit may be challenged in relation to it, they may come back with a response something along the lines of, well, they deserve it after all the hard work that they've put in. Over the years, they've done a lot of work, and that they deserve something back. Now, again, that just wouldn't be acceptable, but that is the response that it would receive sometimes. And again, my experience of charities where these areas arise, the two most common areas of weakness that seem to arise are relation to credit cards and travel expenses. And I don't know why that is, but those two areas seem to be weak in some charities. So in serious cases, so if there are really serious concerns in a charity come to our attention in a charity, perhaps not just in relation to private benefit, but if there are a combination of issues, private benefit and governance issues, and maybe financial control issues, and if we think it's serious enough, the Charities Regulator can appoint inspectors, and Neil actually referred to a few of those inspections in his talk, and they are appointed under Section 64 of the Charities Act 2009. Now, 4 inspections have been carried out to date. The 4 inspectors' reports are available on our website, and the use of credit cards and travel expenses have been featured in each of those investigations. So I think if you were to read those reports, it's clear that the use of credit cards and the travel expenses that were being paid in those particular cases were not acceptable. Now, there were other issues as well, but I think they were key issues in those investigations. And also, as a measure of how serious these things are, 3 out of those 4 charities are no longer in existence. So it's quite a serious issue when these things come to light. Charities, when these things came to light, the charities were just not able to carry on because the funding the donations dried up for these charities once these issues came to light. So it is quite a serious issue. Now, if you are a charity trustee, how do you prevent these issues arising? Now, I always welcome the opportunity to talk to charity trustees about what actions they can take and how they can prevent these issues arising. So the simplest protection for any charity is strong oversight from charity trustees, and that is the best protection of all. If charity trustees are willing to ask awkward questions, if there's anything, charity trustees should not be afraid to ask any questions, should not be afraid to get any information that they feel they require, And if they can't get that information, they should wonder why they cannot get that information. There should be strong financial controls and division of duties in any charity. Like we get concerns in relation to charities all the time, but the ones that tend to make the headlines, the ones that tend to end up in the newspapers, the ones that cause the real risk to a charity and being able to continue into the future are usually in relation to the finances. People get particularly upset when they see money gone missing from a charity, or a charity having extravagant expenditure. So, Lewis mentioned at the start, my background is as an accountant, so perhaps I am slightly biased towards financial controls, but my strong belief is that financial controls are absolutely key in the running of any charity, and division of duties is also a key area. For example, users of a credit card, if there is a credit card in use by a charity, it shouldn't be signed off on by the same person who spends the credit card. There should be a division of duties. So one person is in control of the use of the credit card, and another person within the charity of suitably senior level, perhaps even up to the board of trustees, perhaps should be looking at this, should be looking at what has been spent on the credit card and seeking, asking questions, looking for backup information, invoices, whatever. And whenever I get the chance to talk to charity trustees, one of the questions I always throw at them and see the reaction is to ask them, if you are now, anyone who's looking at this webinar, if you're a charity trustee, I'm going to ask you a question now. How many credit cards are on issue in your charity? It's a question I regularly ask of charity trustees, and you'd be surprised how often they have no idea. They have no idea if there's any credit cards in issue in their charity. They have no idea who has the credit card. They have no idea of what kind of expenditure is on the credit card. They've never seen a credit card statement, and this kind of issue can create an issue for charities. Travel expense, again, like say travel expenses, which is the other area which seems to come up a lot in charities in relation to private benefit, should conform to revenue guidelines. That's the best way. The charities can have, if they conform to revenue guidelines in relation to travel expenses, they're probably going to be fine. The Charities Regulator is going to raise any issue to it if it's compliance with the revenue guidelines. And these things should be reviewed and signed off on by a second person who's not connected to the first person. Okay, they're simple procedures that should be in place in any charity. Also, the Charities Regulator would urge charities to be transparent. The more information that a charity makes public, the less chance of concern will be raised about them. So that's in relation to any issue in a charity. If basically, I get it hard actually to think of any information that a charity should not be making publicly available. Certainly, their financial statements should be available to anyone who asks them. It should be available on any website. Their full financial statements should be available. And I would question any charity who says that that they don't want to show their private or their financial information on their website. And my question to them would be why. A lot of charities are either funded, most charities are either funded from the publicly by donations from the public, or they are funded by government sources, grants, whatever. So the public are entitled to, should be able to see how charities are spending those funds. Now, this is my last slide here. Like I said, I always welcome the opportunity to talk to charity trustees, and I always mention this guideline here. It's available on our website. It's called Internal Financial Control Guidelines for Charities. Now, this document sets out, it's a simple guideline in relation to the financial controls in any charity. And what I would say to any charity trustee, if you were to go through this this document, if you were to answer all the questions in this guideline honestly, I would be pretty confident that you have good control over your finances of your charity, and that you have good internal financial controls in place. It's my favourite guideline from the Charities Regulator. If it's possible to have a favourite guideline from the Charities Regulator, this is mine, and I always mention the charity trustees as one that's well worth looking at. So I'm going to finish up now, and I'm going to hand back over to Lewis. Thank you very much.
Thank you very much. Really appreciate the presentation, which was really insightful and helpful, I think, for the people attending. I'm just going to put Helen is going to join us now, hopefully, for the question and answer session. And there have been a number of very interesting questions placed on the panel. So if I could just put the first question to Helen, first of all, and of course people can feel free to chime in. But Helen, the first question is, if a person is collecting and then holding funds on behalf of a charity, maybe for example, if they've held an event, a fundraising event, or held a lottery for that charity, how long would it be reasonable for them to hold on to those funds before transferring it to the charity? And is there a clear definition in respect of that?
There isn't a clear, there isn't any specific rules around that, Lewis, but what I would say is that anybody who's collecting on behalf of a charity, I mean, I appreciate it can be difficult for charities because you may not know that someone is collecting on your behalf, but what we would say, and certainly in funding guidelines and other guidelines that are issued by representative bodies, is that you should, the minute you find out as a charity that someone is collecting on your behalf, make contact with that individual. And really there's no reason why anybody who's collecting for a charity shouldn't provide that immediately to the charity once they've collected it. So there are questions to be asked if someone has collected money on behalf of a charity and is then not willing to hand it over. But ultimately it would be for the charity in the first instance to make contact with the individual concerned or the group concerned that has raised the money for them. So yeah, you know, we do come across situations, or certainly I've heard of situations where people are money is sitting in an account somewhere and the charities are waiting, but as I said, it really is something that we don't have statutory powers around that area, so we can't, you know, talk to the individual concerned. What we can do though is make sure that they are in fact collecting on behalf of the charity. So if there was a concern that someone was out there saying that they were collecting on behalf of charity and they weren't, that is certainly something that we could look into. But in the first instance, we would say it would be for the charity to immediately make contact. And there's good reason for that as well, because I mean, as a charity, you may not be happy with maybe the way the money is being collected and that you're being associated with it. So there is a reputational issue there for charities as well. But I think in the age of online fundraising and things like that, it has become more challenging. We do have fundraising guidelines for charities. They don't, to my knowledge, or I can't recall, but I don't believe they deal with that specific issue. But we are looking at revising those, in that we're looking and reviewing those guidelines. They were made or issued a few years ago. So we'll be working with the sector later this year in terms of having a look and seeing if they can be updated in some way, and issues like this no doubt will be covered.
Thanks very much, Helen. That's really useful. Neil, if I might just put the next question to you, and it's an interesting one. It's just, when trustees deliver a service to the charity of which they might be a trustee, can they be paid for that service? And then another linked question that came in respect of that is, when board members provide training to members of a charity, can they be remunerated for providing that training?
Well, thanks, Lewis. I mean, those are interesting and difficult questions, and the answer is it kind of depends. As I mentioned in my paper, there is guidance published by the Charities Regulator on managing conflicts of interest. So I think it's fair to say in the first instance, you can never say never. There may be circumstances in which it may be permissible, but if I could just refer to that guidance, because I think it's very helpful. It includes a number of case studies, some of which touch very closely upon the kind of questions that you've just raised. So, for example, one of the case studies in this guidance relates to circumstances in which, as it says, Teaching Africa Foundation is a charity that provides education resources in a region of Africa and requires a specialist advice in an area in which Aoife, one of the charity trustees, is an expert and runs a successful firm. And what it says is essentially that the trustees decide to engage Aoife's firm to provide that service to them. Now, the guidance explicitly recognises that this is a clear conflict of interest. So Aoife must have declared that interest in advance. And essentially, to the extent that they're going to ask her firm to provide that service, they must do so in a context in which the conflict is managed, and that would require Aoife to withdraw from any decision making in connection with this contract. And ideally, it would also require the charity to obtain quotes from other similarly situated firms which are capable of providing the same service to ensure that value for money is being obtained. So if after all these kind of measures are put in place, it transpires that Aoife's firm is significantly ahead of the others, then the decision to award the contract to that firm could be justified. But if those measures are not put in place, then that looks very much like a pecuniary advantage being secured by a trustee. And if that were to happen, Aoife's firm, as recipient of the monies, would in principle be capable of being sued to repay those monies. And furthermore, any other trustees who participated in the decision that allowed that money to be misapplied would themselves be personally liable for the amount of money misapplied. So, I mean, there are potentially very serious consequences here. But essentially, as I said, the guidance is very helpful. It sets out a number of case studies in which this sort of thing is dealt with, and I would encourage everyone to have regards to that. You know, download it and look at it, study it carefully. But you know, Tom's approach is I think the right one. I mean, insofar as policemen go, Tom's very much a good cop rather than a bad cop, I think, and he's certainly willing to talk things over with people before they become a problem, and that's the objective here. But generally speaking, transparency is key, and making sure that you don't allow trustees who could benefit from any contract to participate in the awarding of that contract. I think you're muted, Lewis.
Apologies. Thanks very much, Neil. If I might just go to Tom then with the next question. Tom, the question that has been posed is, can a charity start a profit-making business within it to fund the charity's activities?
Yeah, this comes up quite a bit. Like I say, the overriding principle of any charity is that it must pursue a charitable purpose. Now, it is acceptable for a charity to have some kind of business element to it. In other words, you can have a charity could have a charity shop where, you know, goods comes in and it sells those goods. People donate goods into the shop and then it sells those goods, and the funds from that shop are used for the purposes of the charity. You know, to help poor people, or you know, help people in Africa, whatever the charitable purpose of that charity is. Now, the key to it is that the business must be ancillary to the purposes of the charity, so that it should still be a charity, first and foremost a charity, and the business that it carries out is ancillary to it. And also, if you think about it, a charity may have assets. Say, for example, it could have been gifted investments or property, and it would be perfectly acceptable for that charity to rent out that property and use the rental income from that property in the furtherance of its charitable purpose. So the key element to it all is that, yes, there can be a business element to it, but it must be ancillary to the overriding purpose, which is the furtherance of the charitable purpose of the charity. It shouldn't be a business in the first instance, it's charity in the first instance.
And if I might just go to Helen just to add to that as well.
Yeah, another thing just to remember as well is that if you're a charity and you have a charitable tax exemption, and you want to get involved in trading activities and you're going to end up with trading income as a result, it's really important that you get approval from revenue in the first instance. So it is important that you update yourselves. And I would say this to charities as a general piece of advice. You know, the Charities Regulator does not manage, and we are not in any way involved in the decisions that are made around the charitable tax exemption. That's entirely run by revenue, and they do have a lot of important criteria and conditions associated with people getting and retaining a charitable tax exemption, and one of them happens to be with regard to trading income. So that would be another thing as well, and the main thing that they will be looking at, and this is something that they can advise you on, but they want to, you know, have a report from the charity in terms of its proposed trading, saying exactly how it is that trading activity will benefit and you know, help it to advance its charitable purpose. So it's just another piece to think of there, if you're a charity that's contemplating getting involved in any kind of trading activity.
Tom, if I could just go back to you with a very specific question in relation to regulation, and that is, can you advise if it's appropriate to have a flat rate in terms of expenses for payment of trustees or board members to attend meetings? And in addition to that, kind of linked to that, is there a recommended rate of mileage, per kilometre mileage for petrol expenses, for example, that the regulator puts forward?
No, the Charities Regulator doesn't get involved in approving rates or setting rates or determining rates of travel expenses to be paid to anybody. Now, having said that, this is again like Helen's last response there. Revenue guidelines are set out in this area. So normally, if the expenses conform to revenue guidelines, to the revenue rates, the Charities Regulator wouldn't have any issue with that. It's only if rates are in excess of those rates, then the questions could be raised. Well, is this in furtherance of the charitable purpose, or is there a private benefit here? So again, the answer to that would probably be if it's acceptable under the Revenue Commissioner rules, it's acceptable.
And then, Tom, just in relation to that that question of a flat rate of expenses in respect of attending board meetings, say a charity is seeking trustees and they say they pay €200 to cover expenses for each board meeting, is that permissible? Again,
it generally wouldn't be permissible unless it's allowed by revenue commissioners in relation to repayment of expenses. So kind of a round sum expense, it isn't normally allowable. It would have to be some kind of specific expense, like a mileage expense or cost of a hotel or overnight stay, whatever is necessary for the purposes of the charity.
Super. Thanks so much, Tom. Helen, I'm just going to come to you with a question, and that is, how are charities to determine what is reasonable remuneration for employees? And then another linked question that came in relation to that as well is, does the regulator set out guidance in respect of reasonable remuneration for chief executives of charities?
No, we don't. There is no guidance with regard to remuneration of CEOs, and the reason for that is that the remuneration of CEOs will be dependent on a number of factors, such as the size, the complexity of the operation, what they're responsible for in terms of the organisation and what they're managing. And what we would say in terms of the reasonableness of salaries that are paid to employees more generally, and that would include CEOs, really it's about market rates. What would a CEO or what would a senior manager or a nurse receive if they were working for any other type of organisation. So for example, if a nurse was working in the public service, then you would expect that if they were working for the charity that they would get a similar rate of pay. So really around the whole area of employment, a big thing is that in the first instance that charities ensure that they advertise any paid positions that they have. So whether taking on employees, that they advertise those, that they invite applications from the wider public. So in other words, that it's not something whereby somebody and you're recommending they might be good for the job and there's no kind of competitive process there. And again, this goes down to transparency and accountability, which we talked about. And then when you're looking at the reasonableness of what people are paid, I mean, that information is generally available when you go out and look for any kind of positions. You can see the amounts that are being paid out there. So it should be possible for charities to find that out. In addition to that, you'll often find as well that where a charity is, for example, mainly funded by a state funder, so there'd be certain types of charities that would be funded maybe 90%, if not more, by the state. And what you'll have in those situations is that there will be requirements around what the funder believes is appropriate. I mean, not every charity requires a CEO, and this is something that we come across a lot. We see applications coming in from charities that haven't even started their activities, and they're already talking about paying a CEO 150,000 a year or something, and they haven't even raised a penny. And that is obviously of great concern, because actually in some charities you may need a project manager. You may be administering a particular program. That might be what you were doing, and you're not going to need a CEO, particularly if they're your only employee, or if there's only two people. So, there has to be, I suppose, a sense of, reasonableness about what boards of trustees are approving. And again, it comes back to, is this required, in terms of advancing your charitable purpose? Does your charity need 20 employees to deliver on its mandate, given what you've decided you're going to do and what you've committed, and given the services that you're providing to the public. So these are all questions, and I would urge charity trustees not to start with the we need a CEO or we need 10 people. You really have to look and justify, because we did talk about, and Neil has touched on it obviously in his talk, and Tom as well. You know, private benefit has to be reasonable, ancillary and necessary. You know, and that's one thing that applies to salaries as well. We accept that they may be required, and that's one of the exceptions when Neil was talking about it in terms of the public benefit aspect. But it has to be, there is this condition, and it is very clear, thankfully now in the Charities Act, that these are the considerations that people must have. Just linked to that point, because we did have a query about it recently. Charity SORP, which is a statement of recommended practice. This is something that charities, for example, in England and Wales and other jurisdictions, are required to comply with when they are preparing their accounts. So Charity SORP is basically a list of criteria that you have to ensure, standards that you have to apply in your accounts. And what it is a recognition that as charities, there are disclosures and things you should be telling people who are reading your accounts that you maybe wouldn't need to, or it isn't required where you were, for example, a commercial entity. And we don't have Charity SORP as of yet in Ireland. We don't have it as a requirement for charities. But we are hoping that once our legislation is amendment, we do need an amendment to our legislation to be able to impose that, and we do think it is required in the sector. However, it would be we would be deploying it in a way that is proportionate. So it would only be certain charities of a certain size that would be required to do it. We've suggested charities that have over 250,000 in income or expenditure. But one of the key provisions of that is that you would have to publish the number of employees in your charity that earn over 70,000, and then you publish the number in each band over that by 10,000. So the number 80, 90, 100. And that would give a greater level of transparency to everybody and to the public about the costs associated with running particular charities. There's nothing to stop charities publishing that now. There's nothing to stop a charity arguably publishing their CEO's salary or any other salaries. However, what they've done in SORP is to do it in an aggregate form. So there may be issues, for example, I shouldn't say there are no issues, but there may be issues associated with privacy and data protection, and potentially maybe conditions that are in somebody's contract of employment that would prevent specific individuals' salaries being published. But again, it is something that we'll definitely see more discussion around when hopefully our amending legislation goes through and we get to introduce those rules with regard to financial transparency in the way that the accounts are presented and the information they contain.
Thanks very much, Helen. Tom, another specific question for you. Is there a recommended minimum spending limit in terms of expenses before a second person should be brought in to sign off those expenses?
No, there's no recommended limit. What I would say is that generally speaking, it's good to have oversight, two people looking at anything, no matter how large or small it is. But obviously there has to be some kind of common sense approach to it. That, you know, €5, is it worth bringing the €5 to a board meeting or to a meeting of the trustees, a board meeting, €5 expense? It's probably not. So that, you know, there should be policy set up in any charity about what kind of level of expenditure would be required sign off at what level and how many people have sign off on it. So again, it should be a policy decision within each charity, which should be reasonable.
Thank you, Tom. Helen, if I can go to you on that.
Oh, now, it's not actually on the issue of expenses, but I was wondering, Lewis, if I could just answer a question that I did see come up on the chat function, but it came up very early on. But I thought it was a really good question in the context of people here today. It was a question about beneficiaries being trustees. You know, so the idea that people who are benefiting from what your charity does, should they be on the board? And this was something that somebody said that they were struggling with. Now, the thing about having beneficiaries on your board is that it brings a really important perspective, and that could be the way in which you get views of the people who are using your services. So there's no rule against beneficiaries being on the board of a charity, and in fact, some governing documents would require that, for example, members of the charity or a beneficiary would be on the charity's board to get that really important input. It's not the only way that you can get input from your stakeholders, but it is one of the ways. The only thing to consider, and that those charities who are beneficiaries, who might be trustees, have to consider, is that when they are sitting on the board and when they are carrying out their duties as trustees, they can't be there representing the interests of the beneficiaries or the people that they're representing. They have to act in the best interest of the charity. So this is all about that area of conflicts of interest, which Neil mentioned, but also conflicts of what we call loyalty. So, you know, having a loyalty to the person who's appointed, or having a loyalty to the people who are using the services. And just to give a quick example, we did have a query, I think it was a few years ago, and it was to do with the fact that a charity had to restrict they didn't have enough money, and they had to restrict the services that they were providing, which meant that they were going to be restricting services to, we'll say, a child who would have been a parent, a parent who was a trustee who had a child who was benefiting. Now, as that parent would have definitely had a conflict of interest with regard to that decision, it was really important that they didn't take part in that decision. So again, there are conflicts, there are these things, it's how they're managed that's really important. But just to answer that important question, that yes, you know, you can have beneficiaries on your board, it is not an issue, but those beneficiaries at all times have to act as trustees in the best interest of the charity. That is first and foremost their responsibility.
Neil, can I just ask you two questions, one arising really from something that you said, and that is, you'd referred to individuals being paid by the charity, and someone has asked, how do you define exactly what is reasonable? And I suppose maybe just to speak to that as a matter of law, how you approach the definition of the word reasonable. Then also, one of the questions that has come through is, can a private individual enforce the Charities Act? For example, if they believe there has been a breach in respect to private benefits, or who does that fall to enforce? Neil, if I can hand over to you.
Yeah, sure. To try to remember them, I'll take them in reverse order if I may. I mean, with regard to the enforcement issue, as I think I indicated, historically, charitable trusts are enforceable only by the Attorney General, and the reason for that is because there is no private benefit involved. It's a public function. The Attorney General is historically regarded as the guardian of the public interest, and it is therefore he or she who has the right to sue to enforce charitable trusts as a matter of historical fact. That function has now been specifically transferred to the Charities Regulator. I think it's by section 38 of the Act, and so it falls to the Charities Regulator to enforce charitable trusts. So to the extent that a private individual has an issue in relation to a charitable trust, in the first instance, the thing to do is to contact the Charities Regulator and bring your issue to their attention so that they can consider it. They also have the expertise to, you know, be able to engage with the charity and perhaps solve the problem without the need for litigation or other kind of wasteful uses of resources. And as we've seen, Tom, in his capacity as head of compliance, is very willing to talk to people and try to resolve these without the need to bring out the big stick. So in the first instance, that's how it's done through the regulator. As to the first question with regard to how a reasonable salary is calculated, I confess it's not my specific area, but I mean, in general terms, the approach of the law to reasonable is that it's an objective standard. So it's to be viewed as a kind of reasonable person. The person on the 46A would view it. You know, how would you look at it, taking into account the particular circumstances of the case? So, as Helen has indicated, you know, the situations will differ, and if you're dealing with a very large charity administering a very large budget with a large number of employees, the salary that's going to be reasonable for the person at the top of that particular pyramidal structure is going to be very different from a charity that's a very small local enterprise with only a couple of volunteers participating. So all I can really say is that it depends, but what you have to do is look at what I suppose a good rule of thumb to start with is, what would someone similarly situated in the private sector earn? And you can take it that that's probably going to be the upper range of what would be permissible, and it would have to be, you would certainly have to be able to justify it by reference to appropriate comparators, I think.
Thank you, Neil. Helen, I'm just going to go to you with a very specific question, and then to Tom for our last question of the event. Someone has just put into the panel, Helen, to ask, when a concern is raised with the regulator in respect of a charity in relation to private benefits or anything else, is it possible for the charity to discover or to obtain information in respect of who is raising those concerns with the regulator?
Well, concerns can be raised with us anonymously. That's the first thing, and we would urge people who are raising concerns to use our online forum, and that will deal with all that for the individual. When we discuss, concerns, and Tom can come in after this and answer this also. But when we are discussing concerns with the charity, there would be no reason for us to be discussing the where this particular concern has come from, and that's one of the points that I always make to people. Like, we're not concerned as the charity regulator who or where a concern comes from. We're concerned with finding out whether there's an issue there or not. So we will look into every concern that we receive. The only thing I would say though is that sometimes we have had situations where people have come to us and they've said, I don't want my name to be mentioned, but then we found out that they've already said to the charity themselves that they were going to bring the issue to the Charities Regulator. So, they've already told the charity that they are the ones who are going to bring it. So, the charity may find out that the person has raised this concern, but it won't be anything to do with the Charities Regulators, because the individual themselves has actually told the charity. Another thing as well is sometimes, because of the nature of the issue, the very concern that's raised, a charity may be able to figure out. I mean, that's always going to be the case. But certainly from the Charities Regulator's perspective, we have no reason to raise at the outset or tell a charity or discuss a charity, who has raised a concern, and we wouldn't do that. We just look at the concern itself and the nature of it, and we set about getting information on that. But as I said, look, you can raise things anonymously with us. That is available to people as well.
Thanks, Helen. Tom, you might want to add in on that in a moment, but just the last question for you. Someone has put in, are there any restrictions on charities disposing of assets at less than the market value for those assets, and in particular to a commercial entity which has overlapping membership with the charity?
Yeah, there certainly are restrictions. The basic duties of any charity trustee is to act in the best interest of the charity. So if the charity trustees are are contemplating selling an asset at an undervalue, the breach of their own duties to the charity, and that certainly wouldn't be acceptable. But again, a lot of these kind of issues can come down to perception and to conflicts of interest, and we've already talked a bit about that. How to handle those issues are to get, if there's consideration of being taken to selling an asset or transferring an asset, that an independent valuation would be got, that if there's any conflicts of interest, that whoever is involved in the conflict would not be part of the decision-making process, and that there's a record kept of how these things are handled. So that's how it would be handled in reality.
Helen, if I could just go to you.
Sorry,
for that.
Yeah, just to say on that, I mean, there's no reason why a charity should be selling assets at lower than market value as a general rule. And acting in the best interest of the charity, you would have to ask, how is that in the best interest of the charity to sell and get less for an asset than the market would give you if you otherwise did it? But at the same time, as Thomas said, there's all kinds of factors that can be considered in that. Also as well, where you have a charity that's disposing of an asset, not to, we'll say, commercial entity, but maybe to another charity, that could be a situation where you might have it being sold for less than market value, for example. But it's the kind of thing that charities have to, I would say, get professional advice on, because there are all kinds of rules applying in certain situations. But the general consideration there, I think, would anybody think it's reasonable for you to sell something? Would you sell your own house at less than market value? That's really what it's about. If you wouldn't do it yourself, then why would you do or think it's appropriate for a charity to do that?
Thank you very much, Helen. So that marks the conclusion of the event. Unfortunately, there are so many questions still outstanding, and the engagement from the audience has really been quite remarkable. I want to take this opportunity to thank all of our speakers and Helen for joining the question and answer session. The Voluntary Assistance Scheme couldn't do the work that it does without people giving very generously of their time and expertise, and that counts this morning as well. So I'm really very grateful to you all for that. In terms of the Voluntary Assistance Scheme, we are really looking for charities and NGOs to engage with us and to put in requests for pro bono legal assistance, which we will then consider. And if you are interested or if you require legal assistance, please feel free at any time to email the Voluntary Assistance Scheme email address, which is VAS, VAS @lawlibrary.ie. That marks the end of the event, but hopefully not the end of the discussion in relation to this really interesting topic. And thank you very much to all of you for attending, and to our speakers again for their very interesting participation and presentations. Thank you very much.